We will begin our question answer session now. We have two questions already. They haven't mentioned the speaker to whom these questions are posed. So the entire panel is open to answering them. The first question that we have is by Ms. Chanjana Philip, who's asking, what would be the liability of the carrier in situations where a passenger contracts COVID?
Giovanni, what is the question? What is the liability of the carrier when the contract with the passenger?
When the passenger gets COVID while traveling.
In case of cancellation, you mean? For the cancellation of
no,
the travel?
in the sense that now that I believe I have not posed this question, so I'm just guessing that the question is, now that airlines have started their functioning, in case the passenger, when they are traveling in the airline, if they contract COVID, what will be the liability of the carrier in such a situation?
In case during the travel, the passenger get sick for the COVID-19. So, I mean, it depends whether there is a lack of protection during the flight. I don't know whether my colleagues, Vincent and Mario, agree on this point. Generally speaking, if the airlines have fulfilled and complied with all the obligations which arise from the COVID-19 regulation, there cannot be liability for the carrier due to the COVID-19 contracted by the passengers during the flight. First of all, it is a very difficult question because there will be, in Latin we say onus probandi, meaning that the passenger who have contracted this COVID-19 has first to give evidence that it happened really during the flight, which to me as a lawyer is also difficult to say. But let's assume that there is a clear evidence that the COVID-19 arose during the flight. If the airline has fulfilled and complied with all the obligations which were imposed by any applicable law, because there is the state law, the international law, safety law, carriage law, cannot be a liability of the airline. Different is the situation from insurance viewpoint. I'm not sure whether you can claim that anyhow there is a coverage for the occurrence of a case during a flight, but in my view there is no objective liability. It is always subjective, so meaning that the airline need to have miscomplied some obligation or some requirement. Otherwise, it will be exempted from this kind of liability. Vincent, apart any other kind of reimbursement or other under the European law, but in general under liability law, I'm saying.
If you allow me, I agree with Laura, but I think that this reinforces my opinion about the sanitary security, because it would be very difficult, the onus probandi. The only thing that probably the passenger could prove is that he was infected during the travel. And I am sure that it depends on the different law courts which could decide about this eventual suit. But generally, there is a liability if the passenger duly proves that he was infected by the virus within the travel. The problem is that, as this is a question of, in my opinion, the third sector of security in civil aviation, the government could be also responsible If I would have a problem in my country, for instance, and an Argentine passenger goes and comes from Europe in 2 weeks, and he gets infected within the travel, well, maybe if it could be proved that there was some defect in the sanitary protocols in the airport or within the air travel, I would shoot not only the airline, but also the airport and the government, because the government is the last responsible person if there are things that have to be complied by the government in order to security, because let's remember that the security is the most important objective in civil aviation and in tourism. So it's a very interesting subject, and it will depend on where and how it could be suited by the damaged passenger in order to know if the law court could say yes or no.
Sorry, Mario, but there is one point. Either you have a liability which arises from something, which exclude negligence, the need of negligence. Otherwise, under the general liability regime, you must be negligent, or at least you can exclude liability if the carrier proved to have been diligent. I just give an example, okay? I agree totally with you that there is a concurrent potential liability of many operator, like the airport manager, like the state agency who are supposed to make the control and so on. But for instance, in domestic flight, okay, where I don't know in France or in Argentina, but in Italy, in pure theory, to fly between Rome and Milan, there are no sanitary control, okay? Because you are not subject when you take your flight to any kind of control when embarking. Of course, you have to wear masks during the flight. However, there is no obligation to, apart testing the temperature, to make any other kind of test for the passengers. So if a passenger which is infected take a flight, and the airline has taken all the precaution, because how can the other passenger be infected? Either because the airline failed to take the precaution, or because incidentally it get in contact during embarkment or with another passenger who was infected. And you are pretty right. The problem is that it could be that no one has controlled, apart the temperature, to be below 37 plus 0.5, but no other control are mandatory during domestic flight. And here is the tricky point. Is it liability of the airline if the airline has fulfilled all the other obligations in terms of distance, in terms of filters on board? So it is a very tricky question, because to me it remains a liability which is based upon negligence or non-compliance. It is not a liability which comes by the fact that you are the carrier. The carrier can discharge liability by giving evidence that it has adopted all the precaution and has complied with any applicable rule. But there can be a loophole, as you were saying, between among the various players. I agree on this point.
Yes, it's very difficult. It's quite different in a local flight or an international one.
If I can add to the discussion, I think as well, and I agree with both Dr. Forchi and Laura Pieralini on what has been said. I think it would be interesting. I think it would be interesting if the case arises in the future to see as well how it affects the interpretation of the Montreal Convention, for instance, regarding the definition of accident, because we know, for instance, the case law in the United States when it comes to accident is very strict. We have all the cases on deep vein thrombosis, for instance, where it is what is purely internal to the passenger is considered as not being an accident. I think that in the future it will have to be seen if contracting COVID during a flight is an accident in itself. Then I totally agree. Even if it was the case, the carrier under the Montreal Convention can always say that it took all the reasonable measures to avoid the damage to be sustained by the passenger. But then, of course, if the airline is complying with all the regulations, and if there is a flow in the regulation, I totally agree with Dr. Folke on this. If the government is not taking the necessary measures, then we will have to seek the liability of the government. The problem is, and I don't know, but on this, well, I know a bit on this, that when it comes to administrative liability, the regimes are very different from one country to another. In some countries, it's very, well, not very easy, but if you can prove a fault from the government and the administration, you can engage the liability. In others, it's extremely difficult, and it will take years for it to be proven and ascertained. So, well, that was my my point of view on this, and you see that I agree with what has been said previously.
Thank you so much. We have more questions. The next question is by Ms. Saukya Patil. She's asking, could the regulation of fares in the long run be a way out for the air carriers?
Well, I guess this one is for me. That's a problem. If we take that's a problem if we take a microeconomic, macroeconomic approach. From one particular airline at one particular point, the regulation of fares can obviously protect the airline, making sure that there will not be price competition. What will happen, and what we know from the experience of the last 70 years of bilateral practice, is that when there is a strong fare regulation, it most of the time gives rise to, well, increased fares. So what does that mean? Is that most of the time only the richest part of the population can fly and use air transportation. So the profitability on each passenger is better, but the market is more reduced, I would say, in this respect. The problem is that in the situation of crisis like it is right now, I think that many governments will think about protectionist measures such as regulations of fare in order to protect on the short term. We know that on the long run, it would be better to maybe open more the markets, because it will, well, make more people fly. And I'm putting aside here all the environmental considerations, but putting this aside. And this is a very basic problem. So we know in economics, it's the prisoner's dilemma. When all the actors know that that one move would be better for the collectivity, but know as well that if they are the first one in making this move, that they can be facing some difficulties. So either all the countries agree, or they will stay with a very protectionist approach. I think that in a very short term, regulation of fares, of course, is protecting the carrier. In the medium and long run, it can affect the general profitability of the sector. I don't know if my dear colleagues have some idea regarding what I just said, but I would be very interested to hear what they think about this.
Oh, well, if you allow me, I agree with you, Vincent, about the need for more liberalization of the market, of the air market, because it improves also the development of tourism. And I am convinced that the wisest policy is the coordinated policy of aviation, civil aviation and tourism for any country. But of course, it depends on how in many countries, in mine, for instance, the airline is technically broken, but is always sustained by the government, and the different governments have made the same. So I don't know in which other situations could be, and it depends also in Latin America, as you know, it depends on the different political policies. We have now a government in Argentina quite different, economically speaking, than the previous one. And so I believe that we are going to live a very constrained market in the civil aviation. And I don't know what will happen with tourism. We do not have a big pardon?
No, I feel called into this discussion due to Alitalia. When you say that the government has...
It's the same, Laura, it's the same situation. If you leave now Alitalia or Aerolíneas Argentinas free to compete, they couldn't fly more than 1 month. But this is subject to different political situations, mainly for the union.
But you know, I keep saying...
I don't know how many unions you have in Alitalia, but in Aerolíneas Argentinas, we have 7 different unions within the airline. Can you believe that?
I'm afraid we have 7 or more. So if I look at the name of unions in Italy, from Cobas, UGL, and others. However, Mario, the Italian situation, as Vincent knows because he has attended many of the conferences, Luis, is a bit peculiar, because on the one side, our government continues to support Alitalia, more or less, because now, for instance, Alitalia is one of the few European airlines who has not yet received any state aids, because it's still in progress, whilst, as Vincent was recalling, Air France and Lufthansa have already received huge support in the range of 2 or 3 times the one which Alitalia will be receiving momentarily. So this is a bit unusual situation. However, even before, in Italy we have the most open market to the low cost. We have all the low cost carriers: Ryanair, EasyJet, Vueling, Volotea, Wizz Air, all. Why? And Alitalia is not anymore the first domestic carrier. The first domestic carrier in Italy is Ryanair.
Well, good for you.
Yeah, I mean, so all the time I keep saying that on the one side our government has sustained Alitalia, but on the other side has opened to the low-cost carrier, which, you know, sometimes we ask ourselves why they have done so. Because, of course, as you said, for the former flag carrier, the opening of the market resulted in huge competition. Therefore, they have increased the losses, because due to the union, the labor contract, the collective agreement, and so on, Alitalia was penalized. On the other hand, they, you know, opening to Ryanair, EasyJet, and the other competitor, continue to spend public money to sustain Alitalia. Nobody knows what is the strategy behind, but this is the situation we face in Italy.
Good.
Thank you so much, all. We have run out of time, so I think it's time to wind up this session. I once again would like to profusely thank Professor Laura, Professor Mario Folchi, and Professor Vincent Correa for joining us today and giving your wonderful opinions about COVID-19 and the aviation industry, and also very patiently and enthusiastically answering all the questions which were posed to you. Thank you so much.